Hello, everyone, and welcome to another episode of the BPA Community First podcast, the Litigators Lens edition. Today, we are discussing an all-important topic that affects every family in Ghana, and indeed affects any person who desires or hopes to leave some form of legacy. I am your host, Peter Kosi Simpson. We will be talking about succession, probate, and administration of estates in Ghana. And to help us unpack this all-important topic, I have with me here amazing lawyers from the firm BNP Associates who will be sharing their expertise and practical knowledge on the subject with us. To my right, I have here Senior Associate Nana Ahin Asan. To my left, immediate left, Legal Associate Mami Efia Frimpoma Jira, and also a legal associate at the firm, Christian Konedu Odami. You're welcome, ladies and gentlemen.
Thank you, Peter. Thank you for having us.
Right. Let's dive right in. Okay, Christian. Many people spend their lives to build up their family, to acquire property, to save money, but few of them take the necessary legal steps to determine or make arrangements to determine what happened to this property and assets after they have died. Why do you think it is important to take such legal steps? And how is one able to do or make the necessary arrangements for such things?
Okay. Thank you very much, Peter. So I'll start off by saying that, scripture says where your heart is. Where your treasure is, that's where your heart is. Yeah. And that if we die, we are not going to carry with you what you have acquired whilst you were here on earth. I am here to announce that the law, thankfully, has more or less reproduced this basic principle of life that no one dies and carries along with him the properties they acquired here on earth. And once you die, the law is clear that your properties will vest in somebody else. Now, as to who your properties will go to or how it's going to be shared depends on the steps you took while you were still alive. So, when you die and your properties pass on, right, that is what generally in law we refer to as succession. Somebody has to inherit your properties. Now, the law allows us to have a say as to who will have our properties in the event of death. When you die, I've already explained succession. So, when you want to have a say, if you die making a will, right, dictating who your property should go to. That is what we generally refer to as testate succession. Then we have intestate succession where you have passed on and at the time of death, you had not made a will stipulating who your property should be given or expressing your intention as to how your properties should be distributed. Now, the law is pretty clear. If I make the will, then I'm able to dictate who my property should go to, right? So as a direct answer to your question, the importance of putting measures in place. In this case, the option is making a will because that gives you the power to instruct how your property should be distributed in the event of death, which we call testate succession. But if you don't make any will and then you pass on, the law is clear. The law has put in place some measures as to how your properties will be distributed in the event of death.
Right. Before we dive more into the testate and intestate succession, why do you think people find it difficult to actually make arrangements for how their properties are shared after they die? Is it some form of misconception? Or maybe it's a feeling that, everybody already knows my intention. They already know who I love and who I want to inherit me. Why do only few people take that step?
I think when Christian was talking, if I'm not mistaken, I counted about 14 deaths in his sentence. He kept saying death and die and death and die if you die and death. And so I think that whole concept of death being so close to having to, or thinking about death being close to having to prepare a will or taking steps to make sure that you've planned your estate in such a way that upon your demise, there will be some form of structure, scares people, because you cannot think about a will without processing the fact that the document you are leaving is a document that will be operationalized at the point where you are no longer alive. And in a superstitious area or country like Ghana, you can't take that conversation out of such a scenario. So it means that I have to be thinking, okay, I'm going to die. And people don't want to think about the fact that they are going to die. So I think that's one of the main things. I think usually we call it the escapism. Yeah, or the escapism mentality. So instead of thinking about it, let me just escape that reality. And then when I die, not I, but when the person dies, then those who are alive can sort out their situation.
And just to add to, Nana, go ahead. You finish.
I believe some people also think that you have to be, wealthy before you can plan your estate, but that is not the case. I mean, sorry. When you come to Ghana, once you mention estate planning, succession wills, people believe you must own, lots of houses, cars before you can, prepare a will. But that is not the case. I mean, you can own little, you can even have as low as 5,000 cedis in your bank account. By the way, Peter, I'm not saying that's your bank account. I know you're very rich, but I mean, you can have that money in your account. You can still decide to, make a will to distribute such, money in your account.
Okay. Okay. Now let's, for our listeners who don't know what a will is, can you tell me what is that concept? What a will is, and who qualifies to make one?
Okay. So, a will, in other words, when you are preparing a will, basically, you are putting your wishes on paper as to how your property should be distributed when you pass on. Now, there are certain legal requirements when you are preparing a will. So the first one you have to consider is that you have to be 18 years or above before you can, be eligible to prepare a will or draft a will, make a will. You must also have the testamentary capacity or sound mind. In other words, the testator or whoever is making the will should be able to appreciate the effect of the will, what he or she is making. So the will is also limited to your self-acquired properties.
Right.
You cannot distribute a family property in a will. Sometimes you might own a property with another person. In other words, there's this joint tenancy. You can distribute your interest only in that property in your will. It also has to be in writing. It has to be signed by the testator, that's the person making the will. And also the signature of the testator must be witnessed by at least 2 persons who are present at the same time when the testator was executing the will. So basically, these are the requirements for the validity of a will.
Okay. So, I mean, the will has to be in writing and has to be signed. Is there any special or specific format that the will has to take? Or are there any technical requirements that will invalidate a will after it is signed? Well, for example, if maybe I am the owner of a property and I want to give it out to Christian and Mami, and they are the only persons who know that I am preparing a will, and they are the only person who actually witnessed me prepare the will and sign as witnesses. It's really some form of some fishy transaction. If you come out and there are other persons who are related to me and they bring this will and it's just Christian and Mami who benefited under the will are the same persons who signed the will, won't it cause some problems? Does the law really allow like things like that to happen, or there are other technical requirements that must be met when it comes to preparation of a will?
Because from what Nana said, if we could just backtrack, Nana mentioned some key players in any will. So for the will, we are looking at the testator himself or herself. You're also looking at the executors. You are looking at beneficiaries. And then the last one is the witnesses. So the testator is the person who is leaving his or her wishes on the paper. Now the executor is the person who is going to rule out the wishes of the testator upon his demise. Then you have the beneficiaries. The beneficiaries are the people that the devices or the gifts are made to. So you give your house to your son, you give your house to a niece. Those are the beneficiaries. Then you have the witnesses. Like Nana mentioned, they are the ones who must watch the testator sign the will as confirmation that these are his wishes. Now, there are a couple of technical things when drafting a will, but one of them is what you have, an instance where you have just mentioned, where the witness is also a beneficiary. The law wants to protect the concept of a will in such a way that people do not necessarily benefit or create that whole fishy transaction, in a sense that they are the ones maybe who push the testator, give me this, and then they are the same people who sign it or witness to it. And so the law says that if you are a beneficiary, you cannot witness the will unless there are more than two witnesses. So if there are more than two witnesses, then even though you are a beneficiary, you can still witness and there wouldn't be any problem. So let's use us four here. So assuming, Christian, would you mind being the testator?
No.
Okay, since Peter is the host, you'll be a testator.
Yes.
So assuming Peter is the testator and I'm Peter's lovely niece, and Peter wants to devise his beautiful car to me, and I'm also going to be a witness. If I witness the will with just Christian, then the law is saying that I would not benefit from that device that Peter has made to me because I'm a witness and attempting to benefit from the will. I'm not getting the car. Okay. But in the instance where Nana, myself, and Christian are all witnesses, even though a car has been devised to me, notwithstanding the fact that I am a beneficiary and a witness, I will still be able to get the car. So that's one technical aspect of drafting a will. But there are a lot more in the Wills Act that we could get into some of that.
So just to add to, so regarding the execution, it's in writing. It can be in your own handwriting. You can pull up a paper right now and then write your wishes down, how you want your properties to be distributed. In the event of it can be typed out. You were asking whether there's a prescribed form. There's no prescribed form. You can pick up any paper, a sheet of paper, and then write down your wishes. Regarding the execution, as Nana and Mami have said, the testator has to sign it. There are instances where maybe he can sign in his bedroom and then come and then acknowledge his signature before at least two witnesses. As he signs, the two witnesses, as Mami and Nana said, they must be there witnessing him sign, or they must be there as he acknowledges his signature. He can also direct somebody else to sign for him. And then the person must be there. He must be there as he directs the person, and the witnesses must also be there as the person signs. Then when the witnesses attest to that, they also have to sign attesting to the execution of the will. They must do so in the presence of the testator. It doesn't necessarily have to be in the presence of each other, but in the presence of the testator. Now, once that is done, that means you have a valid will now. But there are instances where even though the will is valid, one of them has what Mami has indicated as if as a beneficiary, I have also signed as a beneficiary, then any gift that has been given to me is invalidated, not the whole will. The whole will. Now, there's also instances of fraud where someone's conduct or statements, false statements, mislead you into executing. So maybe they pull, there's a draft today, or maybe you can say mistake. I do a draft today, then I change my mind the following day. And then I ask my servant to bring me the one I just did today to sign. Then they trick me into thinking the one I just did today. Meanwhile, they brought the one from the previous date. So I thought I was signing the one I had just executed today. Meanwhile, I'm signing. So instances can invalidate the will. There's also testamentary, and Nana mentioned that one. Someone clearly insane, because the will must be a product of your intentions. Can you really say it's the product of my intention if I am mentally ill? Because then I don't understand what is the will I'm even preparing her. Then there's also undue influence. Undue influence where by nature of the relationship between two persons, and then given the circumstance, we presume that the person may have been unduly influenced regarding the dispositions or the gifts. And there's also coercion. It is not by my own volition. Someone has maybe had a gun. So there's a guy pointed to my head that give me your whole house today, like I think Peter has been doing to you. Otherwise, so obviously it was not for my free volition, obviously. So once these evidence can be brought to the attention of the courts, that can be an instance where a will be invalidated, even though it has satisfied the statutory requirements for the execution of the will.
And Peter, if I could just chip in, I think the writing bit is one that we can't overemphasize, because I once had someone speak to me or was asking, because his grandmother had left a video stating her wishes upon her demise. And so the family was interested in finding out if that wishes or that video can, and I think it's a concept that in some jurisdictions is accepted where they could have a video, but in Ghana, I think we cannot overemphasize that enough, that it must be in writing.
Well, regarding that, in certain circumstances, we may say that you have executed what we call a summon sale or a customary law will. It is not an informal will. It is a formal will which is executed in accordance with a certain custom. The danger with that is that the law is generally not really settled on that. There are a number of judicial decisions by the court, and they all seem to have stipulated different requirements. Some say it must be in anticipation of death. I think traditionally that is the reason why people think if they execute wills, then they are going to die, because they probably feel, because back in the day, traditionally, you are literally on your deathbed and then you declare that I want my properties given to this. So that may be a reason why people feel like if they execute a will, then they're probably going to die the following day. So with a summons sale, it must be done. Your community must recognize customary law will. So if it's not recognized by your custom or your customary law, you cannot execute a summons. So it must be before witnesses. Some are demanding, some customs demand, or some authorities say that your family must even approve the declarations you are making, that you are declaring that this house should be given to this person. There's also a requirement that there must be some acceptance. And then exchange. So even though generally, that is advised, generally, the position of the law is that the will must be in writing so that we can mitigate the risk of fraud. Let it be in writing, either your own handwriting or typed out. But there are instances where a will, what we call a non-cupative will, will still be recognized as, or maybe a will executed by someone in the armed forces. In certain circumstances may be recognized, even though it's not in writing.
Right. So circumstances do change. When I make a will now and later I change my mind, or maybe I have increased the property stock, my property stock. As usual, I do that every year.
Are you remarried?
No, not How do I update my will? I've given something to my child and now he has become very stubborn. I was like, no, this guy, I've changed my mind. Are there circumstances where I can change my mind? Although I've made a disposition, I want my thing back. I don't want to give it to you again. How does that work?
Yeah, it works. So a will is your, like Christian and Nana have already mentioned, it's your intention, your And I think it's the name of it goes to speak for itself. Your will, what you will to be done upon your death. And so you are free to change it at any time. Important things are making sure that in drafting your will, there is clarity as much as possible. Because if you have a previous will in 1945, that's too far. But say you have a will in 2010 and you want to have another will now, you have to make sure that there are express provisions that are either revoking the previous will, or if you want it to be a supplement to the previous will, there are express terms that are stating so. So I think that when it comes to changing your will, one of the things that you would want to make sure is that you are very express in the things that you are saying and then how you draft it.
So regarding that, to add to what Mami said, so obviously it's either you are making another will and then expressly declaring the subsequent will that you have revoked all previous wills you made, or there's what we call the codicil, like Mami said, this was a supplementary, more or less amending provisions in the maybe. And then there's also, even in the will itself, there can be insertions in the will, but it must be executed. Again, you must sign as the testator, and then it must be attested to. That brings to mind another important principle, that when you are making a will, please make sure the testator's signature is at the bottom or is at the, do you understand? There should be no dispositions after. So any insertions made in the will after the testator has signed and has been duly attested to by the witnesses, the law says it is not going to be recognized. It is invalid. So either you are executing a new will and revoking all previous wills, or you are executing what we call a codicil, a supplementary will, amending, or you are making insertions. But the insertions, for every insertion you make sure the testator signs, and then it is attested to by two witnesses, at least two witnesses, but it doesn't make it tidy. So we often advise that, why don't you do a new will where you amend, you make new declarations in the will, so to speak. Yeah.
Or you can physically tear it up.
Yeah.
Simple.
Okay, I like that one. With some anger. Okay, so having made a will, after my death, those in the will, do they get the property automatically, or there are some processes I have to follow? Even how would they know that I have a will in the first place? Assuming I don't tell anybody that there's a will. Are there certain provisions in the law, or are there certain procedures that guarantee that my will be properly adhered to?
It's not automatic. So, I mean, when we as lawyers, when we prepare a will for our clients, we deposit it in court. After preparing the will, you can deposit it in court. Depositing it alone does not necessarily mean that it's validating the will, but it serves as sense of protecting the will. And you also said, is it automatic if the depositions you made in the dispositions you made in the will?
Yeah.
It's not automatic. Once you die, there are certain processes that one must follow. So in a will, usually you name someone who is called the executor. The executor is a person who will manage or distribute the properties in accordance with the will. So that person who is the executor, once you die, that person has to formally apply to the court what we call probate. So the probate serves as an authority. First of all, the probate seeks to validate the will and also serves as an authority to the executor to distribute the property in accordance with the will. If the person dies without making a will, there are also other processes. So what we call the letters of administration. So when it comes to letters of administration, the law provides for certain persons in order of priority that upon your death, if you die without making a will, those persons can, also apply to the court what we call letters of administration. So those people become your administrators. Once they acquire that authority or the letters of administration, they can distribute your will. The law provides that in order of priority, the surviving spouse can apply, surviving children, surviving parents, and of course the last one being the customary successor. Yes.
Okay.
And if I could just jump in, I think one of the things you talked about was no one knows your will. And I think that's very risky. By all means, don't stand at your balcony and shout, "Good morning, my neighbors, I have drafted my will." By all means, don't do that. But it's very important that once you have a will, at least some trusted persons in your family or some trusted persons know that you have a will. Because even if you deposit the will at the court, once you are dead, I'm sorry, you're not going to come out of the grave to come and read the will. Someone needs to take the steps to have the will read at the court and take the necessary processes. So you don't want an instance where you've drafted a will, all right, you've left your wishes, but because no one knows that you have taken those steps, then it gets us to the point where we have to go through a different process or have the estate impose its wishes on you when you actually took the steps. So by all means, speak to, especially if someone is named an executor or someone who witnesses it, you make sure that those persons at least know that you have deposited it. If you've made any codicil, those people know, so that if there's any eventuality, they are able to pick it up from
So
there.
in practice, we usually give them copies also. So you deposit one in court, then maybe you can give a copy to your executor for safekeeping. You can also give one to maybe one of your witnesses. Or you can keep one somewhere, some corner in your house. Just that you should let your family know where you keep certain important, documents. Yeah.
Just to add to emphasize what Nana said in then how important it is to the law. I mean, the law wants to emphasize that it is not automatic when the testator passes on. You feel like now you've been named in the will, so now the property is yours. So maybe in the will they said that this car is yours, so the Benz is yours. As soon as the testator passes on, you go and start driving the Benz.
No.
There is an offense called intermeddling. Where you are not an executor, or in the other case where, I mean, the other instance which we may discuss subsequently, where the person dies intestate and you are not an executor, you have not been appointed to administer the estate, then you start dealing with the properties of the deceased. The law says that is intermeddling, and if you are charged and convicted, you can be imprisoned for that. So please wait for the necessary processes. So as Nana said, the properties automatically normally vest in the executors. And it's only for the time being. Even for the executors, if they start dealing with the property, and within a certain time frame, they don't take steps. 3 months, the law says they themselves can be charged with intermeddling. So they go to court for, and I said, probate. You get, after the probate is obtained, there's another document, if it involves an immovable property, that has to be executed, that will transfer the property from the estate of the deceased to you, the beneficiary. Now, once it's vested in you, now you can consider yourself as the legal and beneficial owner of the property. But let me add that sometimes, even though said document has not been executed to vest the property in you, the authorities are clear. If there are instances where you feel there's dissipation of the estate, and it is, the law says as a beneficiary, by virtue of your equitable interest in the property, you can take steps to protect or to preserve the estate, at least until the executors do the needful, and then you have the property vested in you.
Okay. So from a survivor's perspective, maybe as a beneficiary in a will or an executor, what are some of the practical consideration in terms of maybe timelines, costs? I mean, what are some of the things I should be looking at in order to administer the estate after the death of the testator? I think those are like practical issues, and it will be important for our listeners to know some of this considerations. Okay,
so I think that first step, a loved one has passed away. First step, did they have a will? Okay, in this instance, we are assuming they have a will. And say that as the surviving spouse or child, maybe you were named as an executor, then now you are going to start taking steps to get the probate so that you could administer the estate. But one main aspect of the issuing of probate is what we call the estate duty. Now, before you pay or before you are granted the probate, you have to make sure that the estate duty in respect of that estate is paid before the court would grant you that probate. Estate duty is basically a tax on the value of the estate. So if the estate is 100,000, typically estate duties will be 3% of the value of the estate. And so, the law says 1 to 3%, but practically we've been seeing that it's always 3% that is charged. So 3% of the estate. And so that's an amount aside the various filings that you'd have to do in court. But that's one big chunk of the money that you would have to prepare to pay estate duty. In terms of timelines, it's typically not a long process if you have all your documents, if you have all the necessary requirements. If you don't, or if there is some challenge to the validity of the will, then you know that the process may be dragged, because then someone who is challenging the validity of the will may file what we call a caveat. Then the process becomes longer. But if you have all the documents, it's a valid will, you have all your documents ready and up in line, then subject to the court's diary, within 3 months.
Yeah, 3 months tops.
Yeah, 3 months, you should have your probate. However, if there are the issues of invalidity of the will, or there's a caveat, or there's some issues, then that may drag the process. Or if the executors are failing to act, and then that may drag them.
From what you just said, I get the sense that the fact that there's a will doesn't mean that there's totally an avoidance of dispute, or the existence of a will does not totally take away the possibility of dispute. So what are some of the disputes that may come up even with the creation of a will?
So the one we as lawyers in practice we get a lot is where someone is alleging that the will is maybe not the will of the testator. There are instances where, for example, where there's a stepmom and stepchildren. Stepchild is saying that all the properties have been given to stepmom, so they suspect that the will is not even her. It's not. So then there's also, especially in instances of intestate, the person dies intestate. There's usually, you see half siblings disputing amongst themselves who is supposed to apply for probate. There's also the one thing that comes up is even with the interpretations in the will, like how the will has been, property has been, there are disputes regarding how the will is to be interpreted. So these things may drag the process. So I mentioned sometimes there are even allegations of, even while father was alive or mom was alive, we suspected that she was mentally ill. So they are challenging the validity of the will on the basis of the person lacking mental capacity. There's also dispute as to who is to be granted to. Sometimes there's, as I said, there's no dispute as to the fact that this is our father's will, but then we doubt it is his signature on the who is supposed to be granted to. And then also my favorite one is, which we are getting now, is allegations of the fact that not all the properties in the person's estate, so the testator may have executed the will at a particular point in time. 5 years down the line, he may have acquired so many properties, or it's alleged. But then the challenge is the person claiming that he has acquired other properties doesn't even have evidence to prove that these are the other properties. I'm alleging that they are part of the estate, which have not necessarily been included. So these are some of the disputes that often come up.
Okay. Now let's flip to the other side. In instances that the person died without leaving a will, I think this presents some practical challenges in our communities, but particularly for the protection of the surviving spouses and children. How does the law protect the surviving spouse and children in this instance? And how is the property or the properties of the deceased distributed Does the law make any provision for that?
Yes, the law does. So when we're talking about the will, basically it's your intention, how you want to distribute that, how you want your properties to be distributed. However, if you die intestate, that's if you die without making a will, that one is governed by the interstate succession law. That's what we call the PNDC law 111. In other words, your properties will be distributed in accordance with the law. So in other words, the state that is deciding how your properties should be distributed. And the law provides for, makes adequate provisions for surviving spouses and children. For instance, where a testator has more than, let's say, has 2 or more houses, the children or the child and the surviving spouse, they have the right to determine which of the houses that they would like to be given to them. Then the rest is shared amongst them and also in accordance with customary law. So in the old days, particularly when the man dies, sometimes the man's family intends to or begin to worry the surviving spouse by throwing them out of the marital home and all that. The law expressly prohibits that.
Right.
The families can't just enter the house and reject the surviving wife and also the children. The law ensures that they are also protected. And it's also a crime.
Surviving wife. Hey, what's this is a surviving husband?
No, but like I said, the olden days.
Oh, shit.
It used to be the wife that suffers the most. The wife and the children that suffers the most. Because basically it's the man that works and provides for the family.
Right now, the women are working. The men.
Well, I mean, it applies both ways. Yeah, it applies both ways.
So I understand there's some form of protection for the surviving spouse and children, but in real life, they still face these challenges anyway. With extended family coming in, we are also entitled to this house. You have to leave. You have to back out. What immediate steps can these people take? To assert their right, to protect their rights, and to protect their interest in the estate.
I think that as a surviving spouse and a child, you first have to understand that the law is on your side. I think that point of knowledge is a good starting point for you to even assess your rights. Like Nana said, if you look at PNDC law 111, it was carefully drafted to ensure that the rights of largely women and children are not undermined. If you look at our customary mode of succession, you realize that the way we have our succession is structured, it usually runs through the male line. And so the law was to ensure that women and children are not disadvantaged in the event of the passing of their husband or their father, or now generally the spouse. And so you have to start from the point where you understand that there is this law that protects me. Further to your rights to benefit from the estates, the law has said, beyond that, if we are looking at who to grant the letters of administration, as the surviving spouse, you are number 1 on our radar. The child, you are number 2 on our radar. Parents, you are number 3. And then the customary successor, who usually during funerals, you realize that they will do a whole, I don't know if I should say it installment. It's not really an install, but they usually would name someone as the person that's OD, the one who has OD Ade. So the law is saying that beyond making you know that you are entitled to benefit from the estate, if I have to give letters of administration to, and that particular document is very important because you are the one who would see to the administration of the estate, and that is where the decisions are made. So the law wants to also ensure that you know that this is your power. And so for anyone who is a surviving spouse, a surviving child, you know that you have a right to benefit from the estate, and you also have the right to obtain the LA from the courts. And so with this knowledge, I think that you should amass all energy and confidence to either start the process yourself or seek legal representation to have the process done on your behalf.
Just to add to it, if they come and they attempt to eject you from the house, you can file a complaint at the police, because that ejecting someone when the deceased has passed on, I mean, in this instance, the intestate, let me call it the intestate, that's the person who has passed on without making a will. Once he passes on, and then family comes to eject, it's a basis to file a complaint, because the law has criminalized such things. Even with self-acquired properties, you cannot be ejected until the distribution of the properties. With family homes, the law says that you have about 6 months to stay in the house. With government properties, 3 months. Then you have to start preparing 3 months. Then you start. If it's the matrimonial home is where the family were residing at the time or before the death of the deceased. And as Mami said, the law has prioritized spouse, and then the children comes next. But for me, the key thing for me is the ejection. If there is any attempts to eject you, please know that it is a criminal offense. And the immediate thing you can do for yourself is to file a police complaint, so that police safeguards and ensure that you are not ejected from your matrimonial home.
Okay. All right. So like in the case of the death, when there is a will, when there's no will, I heard you mention letters of administration. Is it the same procedure like the probate, or what do you have to do?
Essentially is. So also this, so again, once you as Nana said, once someone dies intestate, the law has made a will for you. But it is not automatic that the properties in the estate will come to you automatically as a beneficiary. Someone needs to go to court for authority to administer the estate. In a will, I mean, in an instance where the person had made the will, the process of going to court to be appointed, the only difference is in the will, we already know who has been appointed. That's the executor to administer the estate. So that person knows, and that person, in terms of who can apply, is number one on the list of priority. That's one. Now, regarding intestate succession, this time, the law has listed people who can apply. So as Mame said, wife, number one, surviving spouse. Let me not say wife. Surviving spouse. Then 2 is surviving children. Then 3 is parents. And then the lastly is customary successor. Now, these categories of persons, any of them can apply to court for what we call letters of administration. It's basically authority from the court empowering you to administer the estate in accordance with law, as in accordance with the stipulations in PND's Law 111. So similarly, is also a process you file in court. You need to attach certain statutory forms. You need to, some courts demands that you have to bring an affidavit from head of family, indicating that everything that has been said in the supporting documents are true. Once that is done, the court will grant you what we call the letters of administration. It is published for some time, I think 21 days. Yes. But in certain instances, in certain emergency situations, it can be reduced. And then following up, the order is issued. Now you have the letters of administration. And now you as the administrator, let's say the surviving spouse has now been granted letters of administration. With that document, the surviving spouse can now validly execute documents, maybe such as investing assets, transferring properties from the estate of the deceased to the beneficiaries. So it's not different. I think the difference is in the name given to here.
I think, sorry, just to clarify something Christian said. So when it comes to the affidavit of the head of family, with respect to the application for letters of administration, it is not a legal requirement. In practice, we do that because sometimes we just want to avoid the conflict between the children and the spouse on the one part and also the family on the other part. And in accordance with the PND Law 111, sometimes when you distribute the properties, you distribute it also in accordance with custom, which the family is also, the interstate family is also involved. So it's out of courtesy that sometimes we just, in practice, we include the affidavit of the head of, but it's not a legal requirement.
Yeah. Okay. I think more often than not now, the courts have almost made it a custom.
Well, I think it's practical that the court has to look at each case, because sometimes it's the family that's causing the problem. So how are you supposed to get the affidavit from them stating that everything is all right?
And it can be, the letters of administration can also be, be given to two persons.
Right.
So it could be maybe the spouse and maybe the customary successor, or also the spouse and the child. Yeah. So
okay.
It need not be one person.
As we wrap up, let's do this practical exercise quickly. I'll mention a list of factors. Okay. So when it comes to distribution of assets, that's one factor. 2, processes after death of the testator or death of the person who owns the property. Number 3, protection of loved ones. What are the advantages of dying with a will over the dying without a will, or vice versa, when it comes to these factors that I just mentioned?
Could you hit the factors again?
One, when it comes to distribution of properties.
So should we take it one after the other?
Yeah, we can take it one after the other, or I can just mention all of them. Then you take, it is 3 factors anyway. So Christian, when it comes to distribution of properties, what do you think are the advantages of dying with a will over dying without a will, or vice versa?
Okay, so when you look at, I think it's advantageous or is preferred or preferable if you die executing a will. My reason is sometimes it can get very complex regarding distributing properties in accordance with the stipulations in the PNDC Law 111. When you look at that law, as Nana said, first of all, if the person has one house, it goes to surviving spouse and children. If he has more than one house, the surviving spouse and children must choose one house they prefer. Then it stays, they will own it as joint owners of the property. Then the residue is going to be shared in accordance with certain fractures that are, so in instances where it's going to be shared among 4 categories of persons. There's the surviving spouse, children, parents of the surviving parents of the deceased, and then customary law family. So one will be shared in accordance with customary law. Now, if you look at the fractions, instances where all 4 categories of persons are available, you see 3 over 16 to surviving spouse, 9 over 16 to children, and then you see 1 over 8 to children, parents, surviving parents, and then 1 over 8 to be shared in accordance with customary law. So the question is, if the person has only one house left in terms of residue, how are we going to share this? Now you have to compel, the house has to be sold. And then there's also, you must understand that under the administration of estates, as there's an obligation that as the testators, you have to pay all debts of the deceased before you can go ahead and then start sharing assets in the property. So for me, the question is, it becomes very complex, because how are we going to share one house? Are you taking the roof and I'm taking the ground floor? But with the will, now there's also this argument people make that even as a testator, certain individuals you didn't want to include in your will will now be benefiting from. So an uncle somewhere who never paid your school fees is benefiting from your estate and fighting with your family over your property. So when you make a will, you are able to dictate who the property and even in what eventualities it can. So for example, if you have young kids and you know that someone needs to take care of the properties for them until they come of age, you can stipulate that, okay, finish university, or when you are 25, after you've maybe gotten your master's, you can start running my company, or you can start this property. So it is important, first of all, if you execute the will, you do away or you mitigate the complexities of
Distribution.
and also you are able to you yourself dictate how the properties are how
Now, the second factor is the processes after the death of the testator or the property owner.
Yeah.
Intestate, testate. Compare and see which one is.
Oh, definitely testate. So if you have a will, what's like Christian, we've mentioned this already. You name who you want to administer your estate based on your knowledge of the capabilities of the people within your circle. So you know that this person is not a family member, but this person is someone who is able to administer things properly, or who is able to lead the charge properly. So if I'm preparing my will, I know that, okay, maybe I have my wife, or not my wife, family value. So let's say you know that. So let's say that you know a brother, okay, and maybe your brother is not the best of persons to administer an estate, or you have a mother who maybe is not really good at administration. Clearly, if you are supposed to draft your own will, maybe look at a teacher colleague you have, or a work colleague who the person is respectable, the person knows how to administer property, so the person has some expertise, which makes the person a good fit for the role of an executor. So you may want to name that person. However, if you don't have a will, then the person who will go for the LA is someone who the law favors as somebody who is able to bring. And that doesn't necessarily make that person qualified to be able to administer the estate. So in terms of the processes, I think that's one. The second is, like we said, when it comes to caveats in succession, caveat always stems from who should bring the LA, who should bring the who is entitled to the LA. Usually in a will situation, you have very little caveat in relation to the capacity of the person to bring in the will. You only have caveats in very few instances. But when it comes to intestates, you have stepbrothers, because they are children. Now the court can only give to maybe one mother or one parent, one child. And then if you have two stepbrothers or three stepbrothers, then all the brothers or sisters all want to be called the administrator. So I think that in terms of processes, these are some of the two. And the whole issue of the issue about the head of family. Yeah. You wouldn't have that issue in a probate situation. Okay. Yes. Yeah, so.
Now the final one: protection of loved ones and your dependents. Testate, intestate. What's the advantage of one over the other?
Everything is in favor of the testate. Yes, everything is in favor. For protection, it's on paper. You have it on paper, clearly stated how you want to, you want your properties to be distributed. So, I mean, once you apply for the probate, there's this certainty that this goes to the family, this goes to your, let's say, your wife or husband, this goes to your child. No one, or it's very difficult for you to dispute that. So for the testate, it's always, advantageous to do a will than to leave it to the law, for the law to decide for you.
Yeah.
Yes.
Well, viewers, as we come to an end of this discussion, it is very clear that taking steps to make arrangements for how your estate should be managed after you pass away is not only a legal step, but also a responsibility or a show of care for the loved ones that you leave behind. I'd like to thank very much my able colleagues from the firm who have shared their expertise and practical knowledge with us. And if you find this discussion insightful, share, let other people know, and also leave your comments if you have any questions. Thank you for staying with us through this discussion, and we look forward to seeing you on the next episode.